How's everybody doing this evening? We'd like to welcome you to the Joint Veterans Endorsement Interviews for Judicial Candidates. Today we have Veterans in Politics International, Nevada Veterans Association, and Armed Chambers Forces are currently on the panel. The panel will introduce themselves and their organizations as we go around. After they're done, Judge will introduce yourself, tell us why you're running and why you think you're the best for the department. Please keep it short. Please keep all answers short and out of lawyerese. Please speak to the people directly and concisely. Thank you for being here, and as there is no opponent, there's nobody for us to ask other than you. So,
Sue Christensen, Nevada Veterans Association.
Yadasha Jones, Veterans in Politics.
Gary Jacobs, Armed Forces Chamber.
J.P. Edwards, Armed Forces Chamber.
and before we go any further, I would like to thank our sponsors for this is Jacob Reynolds, Department 29, and Judge Mary Perry, Family Division, Department P. I am Frank Friends, Veterans in Politics, also a court observer.
Good morning, everybody. Thank you for having me. My name is Jerry Wiese. I'm the judge in Department 30. I've been a judge there for the last 15 years. I practiced as an attorney for 16 before that. Grew up in Las Vegas. I've raised my family here. I've got a wife of 36 years, 4 children that are between 20 and 30. And I have a vested interest in our community. I found that as an attorney, I wanted to make more of a difference in the public as a general thing and as a whole. So I ran for judge, and I found that I get fulfillment out of this. I feel like I go to work every day. I try to do the best I can, make the right decisions, treat everybody fairly and with respect. And I'd like to continue to do that. That's why I'm here.
So, Judge, when you see my hand go up like this, that means you have 30 seconds to finish the question. Once the hand starts to close,
I'm generally going to give you a quick answer. So.
That's what we like to hear.
Sue Christensen, Nevada Veterans Association. Should judges impose sanctions more aggressively?
Good question. There are some judges that impose sanctions a lot. There are some that impose sanctions very little. I'm one that imposes sanctions very little. I think that there are other ways to encourage professionalism and respect among attorneys and parties. And generally in my department, sanctions are not generally warranted because I can generally talk to people in a way that convinces them to work out their problems and to communicate respectfully with each other so that sanctions aren't warranted. They are necessary in some instances, and I'll impose them if necessary. But I don't think that they should be imposed more aggressively because I think it lessens the professionalism and civility among lawyers when everybody's getting sanctioned.
Yadasha Jones, Veterans in Politics. In the Robert Tills murder case, you denied multiple attempts to remove Judge Levitt. How do you see your responsibility to protect fair trials from judge shopping while still guarding defendants' rights?
Okay, so I don't have an independent recollection of that case. It was Judge Levitt that I...
Yes, the guy he kept requesting a new judge.
Okay.
Multiple times, and you denied him.
So what was the question in relation to that?
How do you see your responsibility to protect fair trials from judge shopping while still guarding defendants' rights?
So everybody deserves that right to have a fair judge.
Right.
As a chief judge, I have the obligation of ruling on affidavits or requests for disqualification. There are certain things, case law and statutes and rules that I have to look at in determining whether or not a judge is going to be disqualified or not. If it doesn't meet the rules, I don't grant them. It's really easy. I think everybody's entitled to a fair judge, and there are times when I've disqualified judges if there's evidence that they have been unfair or biased. Apparently in that case, I must not have seen anything that met the rules of the statutes.
This was the Review Journal case.
I'm sorry.
I know you've done a lot of cases.
I probably rule on about 4 or 5 affidavits for disqualification a week in the last 3.5 years. So, sorry, I just don't have a recollection of that one.
Thank you.
Gary Jacobs, Armed Forces Chamber. How do you ensure your rulings are grounded in statute and precedent rather than personal philosophy?
First of all, you need to know the statutes and the precedent, right? Or you need to research them, and I try to do that in every case. obviously a person's personal philosophy is going to come into play, but I think it comes into play more in terms of how I treat people, how I speak to people, and how I respect people. When it comes to applying the law or making a legal decision, those should always be based on rules, statutes, precedent, and the things that don't have emotions behind them. I try to do that in every case.
JP Edwards, Armed Forces Chamber. Describe a time when you had to make a legally correct decision that was unpopular with clients, colleagues, or the public. How did you handle it?
Okay. Back in 2012, I had a decision involved a project labor agreement. So labor unions were in favor of it. The non-labor unions were against it. I had a courtroom full of people. I looked at the law. The only precedent we had was a water case that was about, 15 or 20 years earlier. I looked at what the Supreme Court did in that case and the things that they thought were important. Based on those things that the Supreme Court thought were important, I evaluated the case and I said that I thought that the project labor agreement was valid. It went up on appeal. The Supreme Court kicked it back and said they wanted me to do something different, that they didn't want me to look at precedent, that they wanted me to look at the current economic climate in southern Nevada. In looking at that, I still thought, well, these are the things that were important in the evaluation the first time. I said the only thing that I thought was maybe odd was that if a non-union contractor got the bid, they could only bring a certain number of key employees. So I said, if that's the case, maybe that's not fair, and you need to change that. Unless or until you change that number, then I'm going to say it's not valid. It ended up going up on appeal, and the Supreme Court didn't do anything until the bid was, the county awarded the bid to somebody else. I'm out of time, sorry. I didn't get to finish the answer.
So, Frank Friends, Veterans in Politics. So, on average, before somebody commits their first murder, they usually see a judge or an arrest or some type of record, event 11 times. With judges knowing this, and they do know this, they're armed with this information, but yet they're continuously allowing violent criminals and felons back out into the streets to harm innocent people. You as a judge, if somebody's continuously coming before you or their record comes before you and you see that they actually are a danger to the public, because that's the reason why they're in front of you in the first place, are you going to continuously err on the side of caution like these judges do and legislate from the bench? And are you going to worry about their sexual orientation, their race, religion, or background? Or are you going to look at the facts in front of you?
Well, hopefully I'm going to look at the facts in front of me. If somebody's a danger to the community, then they should be incarcerated. If we know somebody's been convicted over and over, or they've got lots of crimes and they're a menace to the public, we don't want them on the streets, right? I mean, if somebody can be rehabilitated, then there's probation, specialty courts, and other things. But what you're telling me is this person's not somebody that can be rehabilitated. It's somebody that's a bad guy. So they should probably be in prison.
Sue Christensen, Nevada Veterans Association. How do you handle cases where the law is clear but the outcome feels harsh?
If the law is clear, even if the outcome feels harsh, that's the outcome. Because as a judge, I need to follow the law, whether I like it or not. I told you I'm going to answer the questions pretty quick, except for his.
I like it. Caught her off guard.
She went ready.
Yadasha Jones, Veterans in Politics. What do you do to make sure ordinary families and not just attorneys and insiders experience your courtroom as fair, respectable, and efficient?
So one of the things that I want to change the most about the court is the fact that we don't get cases to trial quick enough. And I don't think it's necessarily, I think generally the attorneys are okay continuing cases multiple times. But I think the individuals, the plaintiffs and the defendants and the parties to the case want resolution quicker. So my goal as a chief judge for the last 3.5 years, I've been trying to get more judges. I've been trying to get more space so that we have more courtrooms, so we have more judges. We can give people trial dates quicker and resolve cases quicker. And I think that's the the thing that I've been working on, at least most recently, in trying to help the people as opposed to the legal community. Does that answer the question?
Yes.
Okay.
Gary Jacobs, Armed Force Chambers. What is your philosophy on sentencing discretion in emotionally charged cases?
Emotionally charged cases, generally it's emotionally charged for the parties, their family, sometimes the community and the media. Hopefully it's not emotionally charged for the judges. So my goal in all cases is to try to keep the demeanor calm in the courtroom. Generally, the judge has a lot of influence over that based on how the judge acts. As long as the judge stays calm, generally the people stay calm, and emotionally charged cases don't necessarily need to be emotionally charged.
JP Edwards, Armed Forces Chamber. Piggybacking off of that, how do you interpret your role in managing courtroom efficiency without sacrificing litigants' due process rights?
Like I said, I think cases need to be tried quicker. At least we need to give people an opportunity to get a case to trial. I would think between 18 and 24 months. I don't think that gives up anything. The only problem with that is we just don't have enough judges and courtrooms in order to give people a trial date that quick. Last legislative session, I asked for more judges. We didn't get any more. We're in the process right now of having a weighted caseload study performed by the National Center for State Courts. And we're going to let them tell us how many judges we need to be efficient in our jobs. And we'll allow them to present that to the legislature and to the county. And hopefully we get the judges that we need so that we can give people a more quicker resolution of their cases.
Frank Friends, veterans in politics. So on average, when somebody commits a murder, they usually get about 30 to life year sentences. You know what I mean? We are a death penalty state. However, because our DA is so soft, the taxpayers spend $1.2 million to $1.8 million for that sentence on that single person to house them. When we have a death penalty here, we haven't used it since the 70s. We have clear cases in which it should be used. The road rage incident, the other one where that dude killed that little 2-year-old and our DA just cut him a deal. So as a judge, and you're seeing this, how do you feel about these soft sentences? And if a death penalty case came in front of you, I know they say that you can't take it off the table, but is it something you would consider not only for the justice that is necessary, but to save us the tax dollars and allow the public to be safer from these menaces who are doing these things?
Okay, so kind of in response to Mr. Edwards' earlier question, this is an answer you may not like. All right, so may not be a popular answer. Personally, I would have a hard time pushing the button to kill somebody. So if I wouldn't be willing to kill somebody, I have a hard time saying that somebody else needs to push that button and kill somebody. So I'm not a big fan of the death penalty. That being said, the death penalty is part of Nevada's law, right? So if somebody's sentenced to the death penalty here, I mean, I don't know why we don't do that. It's not up to the judges. We've got cases where people have been sentenced to death, and I don't know if it's the Department of Corrections or the governor or whoever does that, who makes the decision whether or not somebody's executed, but it's not us. I know that we have 4 judges who do homicide cases. They're the only ones that are presented with death penalty cases, and I know that we've had multiple cases since I've been on the bench that defendants have been sentenced to death. I mean, I agree with you. It costs a lot more money to house them than it does probably to terminate them. But at the same time, I don't want to be the one pushing the button.
Sue Christensen, Nevada Veterans Association. What should happen if a prosecutor fails to disclose evidence?
If a prosecutor fails to disclose evidence, then the defendant didn't get a fair trial. So I think it should start over, or the case be dismissed. I mean, it's not fair. It should be fair for both sides. I told you.
Sharp.
Dr. Jones, Veterans in Politics. You said a good judge must follow the law even when he or she personally disagrees with it. Can you share a concrete example of when you did that and how you handled it in the courtroom?
How I ask it again, if you would, please.
You've said a good judge must follow the law even when he personally disagrees with it. Can you share a concrete example of when you done that and how you handled it in the courtroom?
When I disagreed with the law but ruled in based on the law anyway.
Yes.
I'm going to go back to Mr. Edwards' question that I didn't get to finish earlier, because the Supreme Court reversed this case and sent it back down to me and told me to do something different.
Yes.
I didn't agree with that.
Okay.
I thought I did the right thing the first time. That's why I tried to make it very easy the second time for them to resolve it by just changing the number. That didn't happen. It got appealed again, and it sat at the Supreme Court until the bid got awarded to a non-union contractor. I didn't like how that played out, but I followed the law. So, and that ended up getting me an opponent in 2014.
Gary Jacobs, Armed Forces Chamber. How do you apply Nevada's evidentiary rule when determining admissibility of social media evidence in criminal trials?
So I have not, just so everybody understands, I've been the chief judge for the last 3.5 years, so I have not done a trial. I did 7 years of civil trials, and then I did about 4 years of civil criminal. So I've done criminal trials. I don't know that I had a criminal trial where somebody tried to put social media evidence in. I think what I would do is look at what the law says and apply the law as clearly as it's written, either in the statutes or the case law. I think that whether it's social media or some other evidence, I like it when jurors have as much evidence as there is. If the law allows it, I would err on the side of allowing evidence, just because I think the more evidence that a jury has, the fairer the outcome.
J.P. Edwards, J.P. Edwards, Armed Forces Chamber. What is your interpretation of the standard for judicial recusal under Nevada law, and when would you, on your own initiative, raise a potential conflict or recuse yourself?
So, as a chief judge, one of the things that I do is motions for disqualification. So I deal with recusal and disqualification all the time. Nevada Rule Judicial Conduct number 2.11, or EDCR 1.230 are the rules that talk about what a judge needs to look at in determining whether or not they should recuse from a case. In general, it's if I can't be fair. If I can't be fair to the parties because I have a relationship either with the attorneys or with the parties, or for some other reason I have a bias or prejudice that's going to cause me to feel one way or the other without considering the facts, I should recuse. Now that being said, as judges, we all have to do fundraising and stuff like that for judicial elections. The fact that somebody gives me money doesn't mean that I can't be fair to the other side, because everybody knows, at least with me, if you give me you give me money for a fundraiser because I'm running for election, it doesn't buy you favors. It hopefully just gets you a fair judge on the bench.
Frank Friends, veterans in politics. So even in this day and age in social media, you actually start seeing a lot of false allegation cases, from the Eugene Carroll to the Brett Kavanaugh to the Duke lacrosse team to Mattress Girl to the baseball one recently where the dude lost a $36 million a year contract because they were falsely accused of sexual improprieties. Once the evidence came to the judge said, there's no evidence for this. This couldn't have happened. This didn't happen. Even your witnesses say this didn't happen. But yet, with public opinion and social media, these people are ridiculed. They lose out on money. They lose out on all this time, all this, basically the process is the punishment. In cases like that, would you be opposed, or is there a current law that you know of that will then give the accuser the exact same amount of time that would have been served by the person they accused? And would you be okay with something like that to prolong the justice and to stop people overloading the court with false allegations?
The only rule or law that I am aware of that would address something like that is somebody can be challenged with an abuse of process claim. It's very rarely used because it's hard to prove. Because there has to be intent to abuse the process as opposed to using the legal system to address wrongs. And it's very hard to prove that intent. But I think that's the only law or rule that would allow for that. And I don't know that it's going to give them the same amount of time or the same type of penalty or anything like that. I think it's just the only thing that you can do if somebody is actually abusing the process. We have one of the things that I do and other judges do is if somebody's a vexatious litigant and they are filing things all over and over against people without a basis, they can be deemed a vexatious litigant and their ability to file with the court can be limited, but it doesn't give them a punishment.
Sue Christensen, Nevada Veterans Association. How do you handle and address complaints about judicial misconduct?
So they shouldn't come to me. Complaints about judicial misconduct should go to the Commission on Judicial Discipline. If somebody comes to me with a complaint that some judge did something wrong, we generally will tell them this isn't something that comes to the chief judge. It goes to the Commission on Judicial Discipline. Under the Hofgren case, I have the obligation as a chief judge, if I'm aware of something that a judge has done something unethical or illegal, then I have an obligation to report it. So sometimes somebody will tell me something and I have to do a little bit of investigation. Sometimes that results in me contacting the Commission on Judicial Discipline. Sometimes it results in me taking no action because I don't find that it's something that I need to report. Does that answer the question? It does. Okay.
Yadasha Jones, Veterans in Politics. As Chief Judge, do you think Nevada's current sentencing laws for drug crimes give judges enough authority to impose strong consequences when necessary, or are these changes you would support to better protect public safety?
For drug crimes?
Yes.
So I may have a different view of this than other people simply because I oversee one of the specialty court programs. So I oversee the TAP and Open programs, which are programs for 18 to 26-year-old kids. Generally, they're in trouble because of substance abuse problems.
Right.
Okay? I look at kids that are that age as not being past hope. So I really try to help them in the specialty court program. And they get treatment. They have UAs on a regular basis. We do... Sometimes they're monitoring, sometimes they're in sober living homes, things like that. And they meet with us every couple of weeks. They have a PO that keeps much better track of them. So I think with drug charges especially, those are not charges often that I think warrant a lot of prison time. Unless the the substance abuse results in somebody committing a violent crime that kills somebody or commits some other violent crime that there's a victim that's harmed.
Gary Jacobs, Armed Forces Chamber. What is the standard for granting a preliminary injunction under Nevada law, and how do you balance irreparable harm versus likelihood of success?
So you know the standard because you just talked about the irreparable harm and the likelihood of success. So that's the standard, right? So I have to look at whether or not there's going to be irreparable harm and what is the likelihood of success. Generally, when you're looking at a temporary protective order or a preliminary injunction, they kind of have similar standards. You have to look at whether or not if I prevent somebody from doing something or I require somebody to do something, how does it affect them? How does it affect the other side, right? And is it fair, right? And generally, I look at that standard oftentimes when somebody's asking for me to stay a case because it's a very similar standard. And again, if I've made a decision and they want to take it up on appeal, they want me to stay the case, and I have to look at what's the likelihood of success on the merits. Well, if I already ruled one way, why would I think that the likelihood of success on the merits is going to be something different? So does that answer your question? Okay.
J.P. Edwards, Armed Forces Chamber. In a politically sensitive public corruption case involving a local elected official, how do you ensure neutrality while maintaining public confidence in the judiciary?
Good question. Because we've had that, right? We've had issues with public officials. I can tell you that there are some cases, and my personal opinion as a chief judge may be different from other chief judges. Let me just start with that. Because I think that there are judges who don't necessarily have a bias because they don't know this political figure or they don't know them well. And I look at it like, if you don't know that person well and you can be fair, then you can take the case, right? There have been people who, we have judges who have had cases before, and if it goes through 6 or 8 or 10 judges and you got 8 or 10 judges that have recused on the case because everybody thinks that they're not going to be able to be fair, then I'll ask for a senior judge to come down from Reno, or we'll ask for a judge from another jurisdiction to do that. It's rare, and I only do it as a chief if I get to a point where there's been a number of judges who have recused. Because generally, if I allow the system to play out, I'll get to 3 or 4 judges recusing, and then somebody will take it and they'll say, yeah, I don't know this person well. I'm fine being fair with it, and I'm okay with that.
Frank Friends, Veterans in Politics. So let's say a litigant comes before you and they do have some issues that they need to resolve and or work through, and you have found out that they have never been asked if they were a veteran, which is what's supposed to standardly happen. You know, when they bring a case to you, it should have been asked ahead of time, but it's not asked. Will you ensure us that you will ask every time to make sure that this veteran may get the help that they're needed and or have a different community and understanding as to what they could be going through from PTSD, times of service, and other issues that they could face?
So that it's generally up to their attorney to bring that to the attention of the court. But I can see that there would be defense attorneys that wouldn't ask that question and not raise it to the judge. So I think it is something that we should ask people. Maybe when we do our plea canvas to if we're going to accept a guilty plea, we should maybe include that question. You know, are you a veteran? Because if they're a veteran, then they potentially qualify for a veterans court. And depending on the crime, the nature of the crime, what the sentence is, if they're going to get probation or not. We have a veterans court specifically for that purpose, to help people that have, PTSD and other things that would affect their ability to be stable members of the community, and we want to help them as best we can.
Sue Christensen, Nevada Veterans Association. Should judges strongly encourage settlement?
I think yes. And I'll tell you why, because my experience having done trials as an attorney and having done lots of trials as a judge, 100% of the people that go to trial think they're going to win. 50% are wrong. And they don't know they're wrong until a judge or a jury tells them they've lost. And it's kind of disheartening to watch somebody walk out of a courtroom at the end of the day with their head hung low because they thought they were going to win and they lost. Settlement resolves that, and it takes away that risk. So I'm a big proponent of settlement conferences and mediations. I don't compel people to settle. I don't strong arm people to settle, but I encourage them to try to work out their differences so that they have the opportunity to be involved in the resolution of their case, as opposed to leaving it in the hands of a judge or a jury that knows far less about their case than they do.
Yadasha Jones, Veterans in Politics. Which constitution do you most align with, state or federal, for the judicial, and why?
I don't know that they're different. The state constitution and federal constitution, I think I align with both of them. As far as the judiciary is concerned, both of them set forth standards for what the judiciary does, what our role is, and how we how the separation of powers works. I don't know that I would say that I align with one more than the other. If you can tell me how you see them different, maybe that'd help me.
People see them differently, but with the Constitution, in the Constitution, we have the Constitution Amendment. Which of the constitutions do you align with the most?
Which of the constitutional amendments?
Yes.
Oh, I don't know about that. We have a lot of constitutional amendments, right?
Yes. And with you being a judge, is there one that stick out the most that you align with?
Probably due process. I mean, 14th Amendment due process rights. I mean, everybody is entitled to due process in a case. So, I mean, I don't know if that's what you're looking for, but
Yes.
yeah, everybody's entitled to due process. So, as a judge, I think that's probably one of the most important things we need to focus on. But I think that's in the state and the federal constitution. So,
Gary Jacobs, Armed Forces Chamber. What is your approach when a prosecutor or a defense attorney repeatedly fails to comply with discovery deadlines?
if they fail to comply with discovery deadlines, the evidence that they try to get in a trial shouldn't come in, right? So if we're talking about discovery deadline and you've got a lawyer that doesn't produce documents and then they want to bring those documents in at the time of trial, I don't think they should be able to. If they don't identify an expert within the time deadlines that they're supposed to have an expert disclosed, they shouldn't be able to bring that expert at the time of trial. I mean, there's rules, and the rules are there for a reason, right? So we need to comply with the rules. If you comply with the rules, then you get the evidence in that you want to get in. If you don't comply with the rules, you shouldn't get it in.
J.P. Edwards, Armed Forces Chamber. Tell us about a legal position you once strongly held that changed after further study or experience. What caused that shift?
This is going to be a weird answer for you. So I've always felt like the right to vote for judges is something that we should never give up. Because I think if we give up a right to vote for anything, we never get it back, right? Once you give up that right, it never comes back. And I've always held that position very strongly. With some of the appointments that we have in the judiciary, I have come to find that I think, at least with the appointments, we have some vetting process. You've got a commission of people that are asking questions of somebody that wants to be a judge, and then it goes up to the governor, and they pick up one of the three. I've come. My position on that has changed, and I kind of believe that we generally are getting better judges from the appointment process than the election process. So that's something that's changed in at least in my philosophy. I don't know if that's what you were looking for or not. But.
Frank Friends, Veterans in Politics. So statistically, it's proven that if judges don't continuously let people in and out of jail and juvenile and things like that, by the time they're 27, if you actually harshly throw the book at them, by the time they're 27, they stop recidivism rates, the crime rate, the repeating always stops. So with these judges that are constantly giving lesser sentences or continuously giving multiple chances to people who are continuously hurting the public, at what point do the judges need to be held accountable for continuously allowing this to come back out into the public and hurt the public when your first job is to protect the public?
First of all, I'm not aware of the statistic that you're talking about. So you're saying if somebody goes to prison for a long time until they're 27, they come back out and they're a good person? Yeah, I've never heard that. If that's the case, that's something that we probably need to make judges aware of. I don't know that there's something that makes judges accountable for letting people out with easier sentences prior to the time that they're 27. I think myself and I think all of our judges do the best we can with the laws that we're given to try to balance justice and mercy, right? justice requires somebody to pay the price for their whatever crime that they've committed. But we also want to, if somebody can be rehabilitated, we want to use that opportunity to rehabilitate them so that they aren't committing more crimes in the future. Everybody kind of looks at each case, I think, differently and independently, and we do the best we can with the evidence and the information we have.
Sue Christensen, Nevada Veterans Association. When do delays become a denial of justice?
I think in every case. And I talked about that earlier. I really think that we need to do better at getting people the opportunity to go to trial quicker, because I think justice delayed is justice denied, right? So, and we really need to do better as a court, I think, in giving people at least the opportunity to get to trial in a very timely manner. And if there's reasons to continue cases and everyone agrees, that's fine. We continue the cases. Because sometimes there's additional evidence that hasn't come to light yet. Sometimes they're still working through injuries. So there's lots of reasons why a case might be continued, but we need to give people at least the opportunity to go to trial quickly if everyone's ready.
Dr. Jones, Veterans in Politics. What are three measurable things that you can say that if you're reelected, that you can tell us that you can give to the community?
Three measurable things I can give to the community if I'm reelected. So I will no longer be the judge anymore after June 30th of this year. So I'm going to go back to having a regular docket. I don't know if it's going to be civil or criminal, or what I'm going to be doing at this point yet. But every time that I've run on the platform that I'm going to treat everybody fairly, respectfully. I'm going to be timely, and I always take the bench on time. I give people the time that they need to present their cases. I review the information that is provided to me. I can tell you with the emergence of AI recently, I think it takes judges more time to prepare for cases because we need to verify that the things that are being given to us are real, right? If somebody cites to a case or language from a case or what that case stands for, we used to be able to just assume that the lawyers were giving us the truth because they cited to a case. Now we have to look at the cases, make sure they really exist. But those are things that I think that they're measurable that I'm going to be able to provide. I can't tell you how I'm going to rule on any specific case, but I can tell you that I'm going to be fair on every case.
Gary Jacobs, Armed Forces Chamber. A jury returns a verdict that triggers strong public backlash. How do you address post-trial motions alleging jury misconduct without appearing reactive to public pressure?
So I think I have given a new trial on 2 cases where there was allegations of jury misconduct. In one case, the jury had they conducted an experiment during the deliberations. There was somebody who said during their testimony that they had bent over like this and it didn't cause back pain or something like that. I don't remember the details, but during the deliberation, the jurors came back out into the courtroom and they said, we want to reenact this. So they did that, and there was an allegation that by doing that they had committed jury misconduct. I agreed with them because there was a specific instruction that you can't recreate things and you can't do experiments and things like that. So I gave a new trial. There was another one where one of the jurors had lied to us. It was a medical malpractice case, and one of the jurors had lied about the fact that she didn't have family members that were in the medical profession. So if there is misconduct by the jurors, I grant a new trial.
J.P. Edwards, Armed Forces Chamber. In a case involving allegations of election-related misconduct, how do you adhere to strict adherence to statutory interpretation without appearing politically influenced?
I don't know that I've had a case dealing with a political dispute. I'm imagining a case coming in front of me with maybe another judicial candidate having committed some type of ethical violation. I think as long as it's not my opponent, I think I could probably make the decision and be fine. If it's my opponent, obviously, I'm not going to rule on that because I think I would have some type of a bias or prejudice, or at least the public would think that there would be. So I'd give that to somebody else.
Frank Friends, veterans in politics. So this will be the last question. There's a lot of time and resources that go into charging people with assaults and frays. I mean, you know what that is. But in other states, they have actually passed a mutual combat law that if the two parties agree to fight and no weapons are used, regardless of the outcome of the fight, neither party can be charged with anything. No grievous bodily harm, no injury, no death, no nothing. So if you run your mouth and you choose to fight, that's it. Police don't get involved. Lawyers don't get involved. Attorneys, nothing like that. It's brought the crime rate of those specific things down in these states and these communities. Is that something that you might look into or see as an interest to save time, money, resources, and also bring down crime rate?
It's more of a legislative question. If our legislature decided that they were going to look at that's something that they would have to decide as a law, right? I guess the biggest concern I have is I deal with a lot of the kids in specialty court that have come from gang backgrounds. And you end up with kids that are in gangs, not necessarily because they want to be in gangs. And if you have two gangs that mutually agree to fight and somebody gets killed, and maybe it's that kid that didn't even want to be in the gang, your proposal is hard for me to accept when I have a kid that's in a gang that, yes, was part of the fight but didn't really want to be part of the fight, and let's say that kid gets killed.
Well, this will be for 18 and over because that's the only people that can agree to a combat law or mutuality.
Yeah, but even with 18 and over, you got people that are in gangs because of the way they grew up and where they grew up, not necessarily because they wanted to be in that gang, and that's hard for me to buy into that.
Okay, Judge, if you can give us and the constituents watching a 1-minute synopsis of who you are, why they should vote for you, and why you are the best candidate for this department.
Thank you. Again, my name is Jerry Wiese. I'm the judge in Department 30. I've been the judge there for 15 years. I think I've done a good job. I think I treat people fairly, and I volunteered to be a leader in the court. I do the things that I think I need to do in order to provide justice to the community, and I'd appreciate your vote and your support and going forward. Thank you.
All right, guys, that has been the joint endorsements for Veterans in Politics International, Nevada Veterans Association, and the Armed Chambers Forces. Thank you guys for your time and everybody out coming. Thank you, Your Honor.
Thank you.